and Ms. Barlow. Ms. Barlow and Mr. Horowitz, welcome to the fray. I think I saw you back there. And Mr. Nye is here as well. I apologize for missing you there, Mr. Nye. All right. Today we have a number of motions to get through. What we don't get through today, we will take up tomorrow. You should have received by email a listing of score sheet of the motions and a rough order that will take those up in, separated into groups. Within the groups, we may not stick exactly to order, and we may take up several within a group if they're related at the same time. And so with that, let's take up defendants' motions in limine regarding inflammatory evidence, use of the term murder, and use of the term psychopath or sociopath.
Thank you, Your Honor. I'm guessing from the court's comments, the court wants me to address all three of those. I'll do that then. Your Honor, the motions are brought to the court based on Mr. Kohberger's constitutional rights and the rules of evidence and relevant case law. With regard to the inflammatory evidence, that is requesting that the court issue an order preventing the state from trying its case with an emotional appeal or an excessive use of emotional phrasing or an excessive use of repetitive photographs. Certainly, we understand that there will be photographs that we may not like that come in, testimony that we may not like that will come in, but what we're talking about is an excessive use of emotional appeal. That the examples that we've seen in relevant case law come from State versus Ellington. In that case, the prosecutor repeatedly used a phrase that was inflammatory about the defendant having run over the wife of a witness who was testifying. And that was found to be inflammatory because of the excessive use of that phrase. Additionally, in that case, there was an appeal to juror emotion when the state sought testimony from a witness about why he might have left his job. Those are examples of what we're talking about. The court has to do the rules of evidence balancing test, and to do that after the state has elicited inflammatory testimony is difficult to undo and puts Mr. Kohberger in a position where the jury's already been inflamed. And so we're seeking to prevent that. Your Honor, I will move then to our motion regarding the murder term. This motion is also based in Mr. Kohberger's constitutional rights to due process and to a fair trial. This is not a motion to ask the state not to use the term murder. That's going to come out when the court reads to the jury the charging document. That's going to come out in jury instructions. This motion is about the state, through its witnesses, labeling Mr. Kohberger. That invades the province of the jury. Mr. Kohberger sits here today. He's innocent, and it's up to the state to bring evidence and a jury to decide if that's different. The state, by using that kind of term as applied to Mr. Kohberger, gets in the way of what the jury needs to decide. Back when we were looking at a change of venue in this case, we worked with a social scientist named Dr. Amani El Aleli, and she talked a lot about how bias is made in people and how we think about things and how we remember things. And one of the things she talked about, and her report is in the court record, one of the things she talked about is the influence of people in a position of authority. And for the state to come in and label Mr. Kohberger in their position of authority or ask a witness, especially a witness in uniform, to do so is very detrimental. It's inflammatory to Mr. Kohberger, and it would—
Outside of opening statements, perhaps, where the state might say, we intend to prove the defendant murdered the victims. Perhaps in reference in voir dire that, in this case, the defendant is accused of murder. I'm having a trouble understanding how this would come up during the evidence phase of things.
Your Honor, that's why I'm asking the court to issue an order to prevent it from coming up.
Sounds like you're asking me to issue an order that says the state shall not commit prosecutorial misconduct, or the parties will follow the rules of evidence.
Your Honor, I would like an order that the parties will follow the rules of
I'm
evidence.
sure the state would like one too.
I'm not going to oppose that, Your Honor. We'll get to the state's motion.
I don't think I need an order because, as the name implies, they are rules, which means they will be followed.
Your Honor, in an abundance of caution, we bring these motions, and that's based on review of case law and based on years of experience when things happen in trial. I found and I believe that it's relevant to bring these kinds of motions before the court now and have all of the parties aware of.
I think there's maybe a difference between bringing them to make sure that the issues are highlighted and the parties are vigilant versus perhaps entering sort of prescriptive orders that are so broad and vague in nature that they are essentially meaningless.
Your Honor, this is my opportunity and the place that is reserved for the defense to bring these motions. I think that they're important motions, and with court's orders, it makes it more clear. Even if the court order isn't spelling out, you can't say this, you can't do that. I think there's an awareness, and I think it's relevant to have that order. I think it's important to have that order. And most of all, I think it's protective of Mr. Kohberger's constitutional rights to have that order. That's our request with regard to.
Address sociopath or psychopath. That
Yes,
seemed
I'd like
the
to
state
address.
was intending to go there, but you're welcome to address it.
Your Honor, if the state is stipulating not to use those terms, I don't need to make a full argument on that, but I'm prepared to do so. I'll be brief. Then with that, we brought this motion again under Mr. Kohberger's constitutional rights to a fair trial and due process of law. This motion is really spelled out in Dr. John Eden's affidavit when he talks about the unreliability of tests that might label somebody in that particular way and the danger of having that label applied to somebody. If that's allowed to happen, then Mr. Kohberger is colored with an opinion or a way the jury will view him that is unfair. And our request is that the court not allow the state to label him in testimony as a psychopath or a sociopath, because any kind of testing is unreliable. That would relate to, or that would become problematic within the rules of evidence to do so, and the inflammatory nature of those kinds of labels would.
I'm not aware of any testing that has been done that has reached that conclusion. Am I missing something?
You are not missing anything. There has not been any testing. There has not been any labeling. This again is my opportunity to bring a preventative motion to protect Mr. Kohberger's constitutional rights. And that's the purpose of that motion. Thank you.
Thompson?
Thank you, Your Honor. And as the court is aware from the responses that we filed, Mr. Nye and I actually kind of divided these motions up. We didn't realize they would be heard together. But as to the inflammatory evidence, what the court has noted is exactly what our concerns are. In the defendant's filings, he doesn't specify what inflammatory evidence he's concerned about. He doesn't define the phrase exceptionally inflammatory, nor are we aware of any definition of that. The words just seem to be used loosely and freely here. And in fact, in the defendant's reply, he acknowledges at page 2 that he really doesn't even know what he's trying to object to. He's asking the court to presume that something's going to happen or anticipate something without a basis for it. We don't see any basis for the court to enter an order. We intend to conduct our trial professionally, and we anticipate that if there are questions about anything that we do, that there will be a timely objection and the court can address it in that fashion. So our prayer to the court is the court deny the request for orders that the defendant has made and simply preserve the defendant's opportunity to object if something of concern comes up in the future.
Your Honor, just briefly, the purpose of using exceptionally inflammatory is used in conjunction with our recognition that in case law, photographs that we might not like will come into evidence. Exceptionally is to define what we mean. And we mean when it's over the top, when it's unnecessary, when it's going to inflame the passions of the jury, and that tips the scale of relevance. We don't know exactly how the state's going to try its case. We do know there are over 13,000 photographs, hundreds of hours of videotape, and many, many witnesses who the state will call to testify. We believe that it is imperative that we have an order to prevent the case being tried in a way that presents inflammatory evidence and appeals to emotions for the jury.
All right, the standard for motions in limine, which I'm about to set forth, applies to most motions that we will address today, and I don't intend to repeat this with each motion, but for the record, let me go through it once. Evidence is relevant if it has any tendency to make the existence of any fact that is of consequence to the determination of an action more probable or less probable than it would be without the evidence. All evidence, all relevant evidence is admissible except as otherwise provided by the rules of evidence or other applicable laws of the court or of the state. Although relevant evidence may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice, confusion of the issues, misleading of the jury, or by considerations of undue delay, waste of time, or needless presentation of cumulative evidence. The question of whether evidence is relevant is a question of law to be reviewed de novo, while the decision to admit relevant evidence is reviewed for an abuse of discretion. On discretionary matters, the trial court must correctly perceive the issue as one of discretion, act within the outer boundaries of its discretion, act consistently with the legal standards applicable to the specific choices available to it, and reach its decision by the exercise of reason. So my concern with the motions is not the substance of them in the sense that I think it's appropriate to highlight those issues that everybody should be cognizant of. It's in fashioning an order that has any real meaning because of the breadth and lack of specificity of the motions. With respect to the use of terms psychopath or sociopath, I do understand that there is no evidence that the defendant specifically has been tested and found to be with that diagnosis or personality disorder, if you will. And I understand the state is not intending to, at this point, seek to attach that label. Absent evidence, competent forensic evidence, if you will, qualified expert evidence, and I haven't worked all the way through penalty phase, and I suppose that could come up in penalty phase of things, but for now, certainly for the guilt phase, innocence phase of the trial, I am ordering that the state and its witnesses not use those two terms or their equivalents. If something happens where you believe a door has been opened before launching into that in front of the jury, you are also required to bring that to my attention outside the presence of the jury. With respect to the term murder, well, let me start with the term murder. So I don't obviously, the jury is going to be charged with what the charge is or our charges are in this case, which include first-degree murder. I don't think there's any problem in using the term murder as it describes the charges and the allegations. Testimony or statements by by counsel or by others that the defendant is a murderer or committed murder, I think would be essentially argumentative in nature at this point. I will tell you that the one thing that will get my dander up quickly is either counsel attempting to argue outside the one opportunity they have to argue in a case like this, which is closing. And I will shut you down faster than you can imagine if I see that. And if I see it again, I will admonish you in front of the jury about it, because I'm serious about not arguing in your questioning or statements or comments between questions and nature of that. And so that would also go with the term murder, I think, to the extent that it reaches a conclusion that the defendant committed murder prior to the closing. Now, certainly the allegation that the defendant committed murder is going to be relevant and probably appropriate in opening statements, perhaps even in voir dire. But apart from that, if you're intending to go there, you need to bring that to my attention outside the presence of the jury. And that's obviously important. Both of those are important to make sure your witnesses understand as well. With respect to inflammatory evidence, I don't know what that is until I see it. And certainly there are rules regarding prosecutorial misconduct. I think counsel is likely well-versed in what those rules are. I'm not one that says I'm going to order that you follow the rules. You are counsel licensed professionally by the bar, admitted to this court. Your obligation is to follow the rules. And that is what I expect of counsel. And so any attempts to skirt the rules without a good faith basis to do so will be problematic. In terms of, and I think really where there's some potential gristle, meat on the bone here, I should say, relates to, I suppose, the photographs or videos of the decedents and the state of the crime scene. This, I would imagine from what I've seen, some of those photographs are particularly graphic, but make no mistake, these murders, whoever committed them, were brutal and were horrific. And so I suspect that the evidence will reflect that. Now, if it comes to cumulative evidence, or perhaps some that are unnecessarily graphic, we can address that on a case-by-case basis. And so I think the idea is before you show the evidence to the jury of that nature, that counsel be given a copy of that. Obviously, if you're going to be seeking to introduce those, they will be given a copy, and we can have a discussion outside the presence of the jury about how many, which, et cetera, will be presented. But I don't feel this really does anything it doesn't advance the ball for me to abstractly say, don't use inflammatory evidence. So I'm not going to do that. I will rely upon the obligations of counsel as professionals to understand their responsibilities. And when it comes to the specific actual evidence, then we can review that before it's presented to the jury. All right. Next is unnoticed 404B evidence and evidence regarding the 404B evidence that was noticed in this case, which is the traffic stop.
I'm prepared to address that, Your Honor. I do note on the court's list, state's motion regarding improper death penalty comments is actually next in order, but we'll take it in whatever order the court
Well,
prefers.
let me, if you want to address that, let's do that first. I apologize. I should have included that within the group because I think it kind of falls within the same category. I think you understand what my rulings are, but I can address it specifically if counsel would like me to.
Ms. James was going to handle that. We're happy to just submit to the
I think
court
it's
on
the
the
defendant's
filings.
motion, so if they want to argue it, they can.
Your Honor, it's the state's motion.
Oh, is it the state's
It is the
motion?
state's
I apologize. Oh, that's right. I was thinking of it in the opposite terms. That's fine. This, if you want to, Ms. Jennings, address that briefly, you may.
Thank you, Your Honor. I will.
And this relates to the concerns that the defense may say something like the state's trying to kill Mr. Kohberger, or something of that nature, as I understand.
Yes, Your Honor. There has been a history in this case of that mischaracterization of 18-4004A. We're just hoping that that mischaracterization is not made in front of a jury. But considering the court's comments this morning, as well as defense counsel's comments, that there shouldn't be statements made whose sole purpose is only for an emotional appeal, I think that this is settled. And defendant replied basically saying the same in their response, that they suggest he use phrases that comport with existing language and statute and jury instructions. And that's what the state is asking for. Thank you.
Any response?
Briefly, Your Honor, we're satisfied using language that's already spelled out by statute, by jury instruction, and that sort of thing.
So with respect to this motion, I think the ruling is really sort of encompassed within my, for lack of better term, ruling or instructions about argumentative comments or statements of counsel. The example spelled out by the state, I think, would fall within that category of being argumentative and would be improper by counsel. And so obviously that shouldn't be done. And so they should comport with the language and at the appropriate time and in the appropriate way that is not argumentative to address that issue. And so they are so ordered. All right, let's take up 404.
Good morning, Your Honor.
That's all.
Your Honor, as it relates to the unnoticed 404B evidence, I understand what's been the discussion on similar verbiage and concerns earlier. However, one of the things that I think it's important to note about this is that although the state has agreed that they will comply with the rule, what we do have so far in self-authenticating records, it's our position is already two mislabels of the evidence. And the specific examples are that technically the DeSales paper, the way that the state wants to use that, would fall under 404B as other act evidence. It's a 2020.
It's a bad act?
It's the rule says other acts to show knowledge or plan. And so the state has expressed that they plan
That's
to use
how you
that
can use it.
paper.
It's
I'm sorry, I can't hear you.
That's how you can use it under 404. The way you can't use it is a prior term of sort of colloquial term is a prior bad act to show that the party acted in conformity with that they have propensity to commit bad acts. For example, as it relates to the traffic stop, I suppose the concern is, well, he committed a bad act of not wearing a seatbelt or following too closely, and therefore he's likely to commit murder. I mean, that's how the rule works. I'm confused about your statement about the prior academic paper, how that would possibly fall within 404.
Well, when in the self-authenticating pleading that the state filed about the DeSales document, they indicated that that shows that he has knowledge of cleaning up a crime scene. So our position is that we don't want to make sure that there's not some sort of in run. The same example that I will give you has to do with
Help me
the
understand here.
Amazon
I
records.
don't think that we're reading the rule the same is the concern I have. And so I want to make sure I understand your position. Because what you're saying is the state's trying to use evidence to show the defendant had knowledge of how to sanitize a crime scene effectively. And that's one way that you can use evidence of a prior bad act that might otherwise be concerning in terms of propensity evidence. 404B doesn't exclude evidence of plan, knowledge, intent, et cetera, that's not anchored to a bad act. And so I don't see how 404 relates at all to the DeSales paper.
Well, it's our position that the way that the state is putting this in is in essence trying to anchor it to a bad act without giving notice of that.
Well, I just don't think your understanding of the rules comports with my understanding of the rule.
All right, well, I appreciate that we have a misunderstanding of the rule. Nonetheless, that's my position. And another example of that is the Amazon records, where they're claiming that those are self-authenticating relating to purchases. And that also has not been noticed.
It's not a bad act to purchase things on Amazon.
But the state is using it, Judge, to show, using it as other things to show a plan or knowledge or intent.
But that is not what 404 precludes. 404 precludes a bad act, a prior criminal act, a prior, but the best term is bad, something that would suggest that it is in your character to commit a bad act, to commit the crime because you've committed another bad act, right? You abused your significant other on one occasion, and therefore you have a propensity to abuse a significant other on a later occasion. That's 404B. Evidence that somebody has knowledge or has a plan not anchored to a prior bad act isn't covered by 404. It's not precluded by 404.
It's our position that the state is trying to do an in run on that with this evidence. And that's why we raise the issue of 404B, anything that's unnoticed, not coming in as a bad act. One of the ways that we contemplated drafting this motion was because there were simultaneous filings of motions in limine, was to come up with a list of things that we were concerned they may call prior bad acts. But because we didn't know what they would raise, we raised it in this form, which is without notice, they should not be able to argue evidence is a prior bad act or make any attempt at an in run on that rule.
So I'm not understanding what you mean by an in run on that rule in this context.
By saying that the argument about the Amazon purchase is that that was prior to November 13th,
Right.
2022, for the purpose of making a plan. And that's the argument that the state will make about that.
I mean, I think I understand what you're saying. I just think we're
So I think,
completely missing
okay.
each other's understanding of the rules of evidence.
Well, I still stand by my position that the state should not be able to in run that. And I'm hearing the state say that they have no intention of doing that.
Well, I'll hear what they intend to do in terms, because I think that your reading of the rule puts requirements on them that doesn't exist under the rules of evidence, but I will listen to their
Okay.
response.
Do you want me to go to the 404B on the video or
On
keep
the,
it
on the
separate?
video of the traffic stop.
Okay, first of all, there's a pleading that was submitted to the court yesterday, and I have 3 copies of the video marked as Defendant's Exhibit D1 that I'll provide to the court for your review at your convenience. One for the court, one for you, one for Ms. McLaughlin. It occurred to me that it would be much easier for you to determine what you thought about this video if you actually got to see it in full. We don't need to play it in court. You can review that at your convenience. It's not our position that the traffic stop equates to a crime that makes someone capable of murder. It's our position that the traffic stop video brings in other acts that the state is trying to end run on. And I want to give you examples. In this video, things that make it more prejudicial than probative are that it provides presence in Moscow. It is at night. It is a visual of the car that is not just the make and model. It is Mr. Kohberger's statement that he doesn't think seat belts provide much in the way of safety. Mr. Kohberger's question about why they need his phone number. Mr. Kohberger's question about how the officer reacts when people lie to him about wearing a seatbelt. If the court allows this evidence in, the state has the ability to use this to make many other points beyond identity. And the jury would have the ability to potentially seek to ask to rewatch the video and draw other conclusions that we are worried about, such as I mentioned, him being at night, not wanting to, it being at night, him not wanting to give his phone number, which could be construed as he wants to hide his identity.
Date of this traffic stop.
Pardon?
Remind me of the date of the traffic stop.
It is on August 21st. So it's
What year?
of 2022. So it's remote. It's
Before the murders.
yes, before. It's clear video of the car as opposed to the videos that are used at 1122 King Road.
Why is that a problem?
Because I think that the state, again, can use this video as an example of where you can see a white sedan clearer than you can see it on 1122 King Road in those videos.
Why is that a problem?
Because there's an argument, the argument could be made that the cars look similar.
Isn't that the whole point of it?
Exactly, and so it's
I mean,
different.
the point of it being, as I understand it, is to show that the defendant owned a white, I can't remember the name, the make.
Hyundai Elantra.
Hyundai Elantra, and that he, as opposed to others, drove that vehicle.
Correct, Judge. And so when this video comes in, it's much more than a witness saying, you know, I looked at registration records and registration indicated that he owned a Hyundai Elantra. When you see it on a video, and then there's going to be other videos that are put into evidence, there's a different argument to be made as opposed to someone verbally reporting a make and model. The state has, the state is.
Sounds like that makes the evidence of, I guess I'm just not tracking again under 404, how that particular issue. Now, there may be the ability to cross-examine the FBI specialists about, well, this video is grainy, how can you make this determination of what the automobile is, et cetera. To me is different than, okay, that's what their conclusion is, which you can attack. The evidence that he has a white Elantra within the years and that he drives it, it's prejudicial in the sense that it doesn't help your case, but I don't see how it's unfairly prejudicial, which is kind of what you were talking about, which is 403. I haven't heard anything that's 404, but
Okay, well, they've noticed it as 404B evidence. So
traffic stop.
I'm arguing it in that context and what other things can be drawn from this video that make it overly prejudicial. The other thing is that the state's expert disclosure by Special Agent Nick Balance lists August 21st as one of the dates that they claim that Mr. Kohberger is near the 1122 King Road residence. And so the date of this traffic stop is relevant to the state for that, their ability to argue that. That also makes it overly prejudicial.
It makes it relevant. It doesn't make it necessarily overly prejudicial.
Judge, the combination of these things is that this video has the ability to be much more than what the state is claiming. The state is claiming that it proves who he is, what his phone number is, and the type of car that he was driving. It's our position that when you watch the video, there are other arguments to be made that make it more prejudicial and therefore excluded when there are a myriad of other ways that the state can prove his identity.
But you don't get
his
to, and I
phone
don't
number.
get to tell the state how to try their case unless they're violating the rules of evidence.
Of course, I don't get to tell the state how to try their case, but I do get to tell this court what our position is regarding that evidence. And when we think that evidence is overly prejudicial and can be construed to do things that the state is otherwise saying the evidence is meant to do. And that's the point of this argument. We ask that you exclude this video, which I will ask that it be, that the marshal provide that to you, and that the state use a different method of proving identity.
Thank you.
I think after what we just heard, we can cut to the chase. The defendant doesn't seem to understand what the balancing test under Rule 403 is. There's no question that the video with the evidence, the defendant's admission of his identity, with his admission and the evidence showing it was his car, the description of the car, the registration of the car, his address, his telephone number, that's all incriminating evidence. That's why the state is offering it. The defendant doesn't like the fact that it's incriminating, but that's not a basis to exclude it. Under Rule 403, in order to exclude relevant evidence such as that, the defendant has to be able to demonstrate to the court's satisfaction that the relevance evidence, that its probative value is substantially outweighed by a danger of unfair prejudice, confusing issues, misleading the jury, undue delay, wasting time, or needlessly presenting cumulative evidence. Just because it's prejudicial, and just because the defendant doesn't like the fact that we can prove who he is, that we can prove what car he's driving, that we can prove what his phone number is, that we can prove his address. I mean, those are all things that tie together to connect the defendant to the homicides. Just because they don't like that isn't a basis to object to it. And so, Your Honor, we would ask that the court deny the defendant's objection to the admission of this evidence.
What about the concern within the video, as I understand it? First, you have what is a 404 issue, which is a prior bad act, though one I'm sure everybody probably in this courtroom has committed at one time or another, of violating the traffic laws in some way, including by not wearing a seatbelt. And so, can you address that part of it, the prior bad act, and how the court should deal with that? And then also, I am concerned with the issue raised about the communication between the officer and Mr. Kohberger, for example, his asking why they need his phone number. That could, I think, be unfairly looked at as if he has something to hide, which would be, I think, unfair. And so I am concerned about that.
And I appreciate Your Honor's comment. I think when you review the video, you can put it, the court will be able to put it better into context. The state certainly doesn't intend to argue or suggest that the colloquy or the discussion between Mr. Kohberger and Deputy Duke somehow showed that Mr. Kohberger was a bad criminal type of person We certainly are not suggesting by any stretch of the imagination, although the defendant alleges it in their response to the state's filing, that the fact that the defendant was apparently speeding without wearing a seatbelt somehow means that he is guilty of murder. I mean, that's a preposterous concept. And the defendant seems to have backpedaled from that before Your Honor just a little bit ago. The state's purpose is to elicit the vehicle and connect the defendant to the vehicle, the description of the vehicle, the defendant's name, of course, his phone number, his address. That's what the state's interest is. And the state, as it views the entirety of the relatively brief traffic encounter, we don't see anything incriminating or making the defendant a bad person out of that. Now, of course, Your Honor will need to see that and decide if its view is different. But we don't see that as being prejudicial. We certainly are not trying to argue some sort of propensity that because he questioned about, why do I need to give you my driver's license, that all of a sudden that makes him a murderer. I mean, that's beyond a stretch of imagination. Does that answer Your Honor's question?
Thank you.
Thank you, Judge.
Response?
Judge, there is a way to, clean this up with regard to this, and that would be to not allow the jury to see the video, to have the officer who made the stop, testify about the stop, testify about the identification, make and model of the car, and the phone number. The argument that the defense doesn't like troubling evidence could be said about every single thing that the state wants to proffer in this case. This is a highly circumstantial case. And so every little fact that is circumstantial is going to be relied upon by the state. And so we have to look at a critical eye with everything that's coming in before this jury to see what the cumulative effect is going to be of that. And so it's not that we don't understand that his identity is going to be proven. As I argued, there are a myriad of ways for them to bring in his identity, but to add all the other components that you will see in the video do much more than just prove that he's Bryan Kohberger with a phone number in a Hyundai Elantra. Thank you.
All right, with regard to this motion and the 404 issue in general, the standard for the admission of evidence that falls under 404 is that the court determined that there is a factual basis by which a jury could find more probable than not that the prior act, if you will, occurred, that the prior act is relevant for a purpose other than propensity, such as identity, and that a balancing test under Rule 403 would not otherwise preclude the evidence, i.e. that the unfair prejudice does not substantially outweigh the relevance. When it comes to 404B evidence, and that's how this was noticed and brought to the court's attention, which is the framework that I'm looking at, 404B does not apply to just any prior act. It applies to prior bad acts, other crimes, other wrongs, not other acts of benevolent or of a type that doesn't implicate propensity. And so I don't see the concerns that were outlined by the defense, for example, related to the DeSales paper and things like that, that's a 404 analysis. That's simply a 403 analysis, which is there unfair prejudice or other concerns that substantially outweigh the relevance? And there isn't the same notice requirement for that issue as there is for 404B. And so I don't see this as the example is raised as a quote unquote end around at all. And so the state does have a notice obligation when it does come to prior bad acts that it may seek to introduce. At this point, they've only identified the one, which is the traffic stop. The Rule 404 requires notice in advance or during trial when the state is aware of the need for it. And so it, I don't think we can say that the shot clock has run out on that at this point. But certainly, as soon as the state is aware of the likelihood of the need for that, they have that obligation to seek that. And at some point, prejudice to the defendant in terms of lack of notice will upend the state's ability to use it if not properly noticed. And so as a general matter, the state is required to provide that reasonable notice set forth in 404B. With regard to the traffic stop, the concerns identified by the defense related to, well, let me go through the 404B analysis. It is technically another prior bad act, which is the sort of colloquial terms used by the courts in describing 404B evidence, in that the defendant was stopped for violating traffic laws and ordinances. I think there obviously is evidence by which a jury could conclude that that conduct occurred. The next question is it relevant for a purpose other than that he has a propensity to violate the laws? I think in this case, there clearly is a other purpose besides that, which is identity, which is ownership of the automobile that is alleged to be a suspect automobile, and control over that automobile. And so I think there is a relevant purpose for it. And the next question is that relevance substantially outweighed by unfair prejudice? The fact that it is more powerful evidence than perhaps a simple description by somebody of DMV records doesn't make the evidence unfairly prejudicial. It just makes it more effective. And that is not the type of unfair prejudice that the rule contemplates. And I don't, frankly, track the defense's argument with respect to that. And so I think as a general matter, the traffic stop is relevant. It's not substantial. I think there is zero danger that the jury will conclude that because he didn't wear a seatbelt or sped, that he therefore has a propensity to commit murder. I just can't imagine any reasonable person coming to such a conclusion. And certainly the jury will be instructed that they may not use that evidence as propensity, may only use it for the relevance of things like identity, ownership, and control. There are concerns that were raised, however, and so while as a concept, I think the video is appropriate under 404 or notwithstanding 404B and 403. I do want the video potentially, I'll look at it and it may change my mind, but just from the description, I am concerned about some of the interactions with the officer about, that was mentioned that, that Mr. Kohberger questioned why the police needed his phone number. That the officer said something about how he views people that don't wear seatbelts. I don't think any of that is relevant. And it does potentially create some unfair, some danger of unfair or unnecessary prejudice. So I think it needs to be redacted to exclude those kinds of things and have the video that shows his vehicle, that he gives the registration, that identifies it as his, that he, his answer to what, not the stuff leading up to what his telephone number is, but if he gives the telephone number, the answer, what the telephone number is. I think that's what we ought to see and probably not much else. So I'd like to see that before it's played to the jury, and you can work on redacting that and showing it to counsel, and within the confines of my rulings, they can raise any concerns they have.
Thank you, Judge.
All right, let's talk about who is going to be in the courtroom amongst the victims and the defendant's family in general, in terms of a reserved seat. I'm not as concerned about the reserved seat part. We can address that at the pretrial conference down the road. I'm more concerned about the ability to be in the courtroom, notwithstanding an exclusion order of the court of witnesses. So let's address that issue.
Your Honor, the state filed this motion in order to seek clarification of the court's definition of immediate family member pursuant to Idaho Code 1953-06-1B. As you know, that specific code section doesn't give us a definition of immediate family member. The state has given a proposed exhibit, State's Exhibit S1, which we think are justified as being immediate family. It's my understanding that defense has stipulated to that list, and we would just ask the court to issue an order to that effect. This takes care of the issue that the state raised. I don't know if you have any further questions.
Well, there is the issue of the defendant's family, but that's, I think, the defendant's motion, so I'll let them address that first.
The state submits that by simply placing our client's family on its witness list, that is enough to warrant exclusion, and further that they may call family members. I want to note that they have not subpoenaed them, the state's attorneys have not interviewed them, and they know that Mr. Kohberger's family does not have any interest in helping them. They also know from watching all of Mr. Kohberger's video visits how much his family loves him and supports him, and that he is absolutely dependent on them, having been in isolation for almost 2.5 years. And by the time we get to trial, it will be almost 3 years. His parents attend every court hearing, and the only reason that they are not here in person is that they do not have the money to fly back and forth from the East Coast. If they had the financial resources, they would be here in person every single court date. Sequestration of witnesses under IRE 615 is discretionary. The language in the statute is that they may be excluded by the court. This means that there's court discretion in that decision, and there's a reason for that. The reason is that the court must balance Mr. Kohberger's constitutional right to a public trial with other needs of the case. In the United States Supreme Court in Ray Oliver in 1948, the court stated, without exception, all courts have held that an accused is at very least entitled to have his friends, relatives, and counsel present, no matter what offense he may be charged. The Tennessee Supreme Court recognized the same precedent in State v. Sams in 1990. In that case, the prosecutor subpoenaed all of the defendant's family to keep them out of the courtroom. In reversing the case over this issue, the court held the assistant district attorney's blatant abuse of the trial court subpoena power for the exclusive purpose of removing the relatives from the courtroom constituted egregious prosecutorial misconduct. The state action violated the constitutional right to public trial, as well as the constitutional right of the relatives to attend the trial. In a more recent case in Iowa in 2022, State versus Bremer, a conviction was overturned when the accused family was excluded from trial due to COVID-19. The court pointed out even the defendant's mother was excluded. The purpose of the witness sequestration is to prevent a witness from tailoring his or her testimony. In this case, all of Mr. Kohberger's immediate family were interrogated in the middle of the night when he was arrested. All of their interviews are videotaped. There's no tailoring of testimony to be done. Add to that the evidence that the defense has disclosed to the state in discovery and expert opinions, which the court has had the ability to review. Those provide an even more narrowing, so it would be even rational probably for the state to actually call. at best, there's one potential family member that they may see a reason to call. The state knows that Bryan's family has no desire to be used as witnesses against him. From the minute this trial begins, the jury is going to study Mr. Kohberger, and they are going to figure out who is in this courtroom sitting behind him to support him. Weeks into the trial, the jury is going to know who's in the gallery. That's why there is a constitutional right to a public trial, so that what happens here is not done in a star chamber. And for our client, the jury will know that he has people there to support him. Mr. Kohberger needs his family to support him. As the court knows, we have several motions that we will be addressing regarding his autism spectrum disorder. He needs to have his family here to support him, and they need to be in the courtroom supporting him. These needs are constitutionally protected rights. We ask that you enter an order making it clear that the state does not get to put his family members merely on a witness list and keep them out of the courtroom. If they want somebody in court, there needs to be an out-of-state subpoena issued. They need to provide witness travel funds to be here and make their intentions very clear. And then this court, we ask, exercise its discretion and allow whoever of those family members the state may actually subpoena to be in the courtroom, because there's no need to worry about how they may tailor their evidence, because it's their testimony, because it's all video recorded. And the court could also order the state to make it those witnesses, if they do intend to call them, immediately call as witnesses early on in the case, so that if there is for any reason going to be exclusion, that exclusion would be there for a very short period of time. But we do ask the court to consider how important in opening statements, when that jury walks in and they're making that immediate first impression assessment, how important it will be for Mr. Kohberger to have his family sitting behind him. We've also asked in our motion that the court address decorum, since the court's going to be issuing an order. As we pointed out, there's been some history in this case with clothing being brought into the courthouse that's pro-death penalty and pro-firing squad. There's no place for that in this courthouse at all during these proceedings. There's no place for that in this courtroom, and we'd ask that the court issue an order that spelling out very clearly that that will not be allowed. Thank you.
Your Honor, the state trusts that this court will enter your own standards of decorum for the courtroom, and the state will advise our witnesses and immediate family in accordance to those instructions, and we expect that they will be followed. Regarding the defendant's family, in no way is the state intending to use its subpoena power in order to exclude Mr. Kohberger's family from the courtroom. The state's not aware of any authority to support this argument that the defendant has a Sixth Amendment right to have his family in the courtroom. He, of course, under the Sixth Amendment has the right to a public trial, but that's not his choosing of who is in that courtroom. Totally understand it's within your discretion to allow certain immediate family members in the courtroom to support
For
Mr.
a reason
Kohberger.
you can't simply take up whatever family members you may need to testify in your case in chief right at the beginning. Other than, obviously I know you have a narrative on how you want to lay these things out, but what I will tell you is both sides ought to get used to the idea that with a 3-month trial, the trial schedule will not be held hostage to your narrative. In other words, we'll be taking things out of order, stopping witnesses to put another one on to make sure we get them through them. picking them up again. And so is there a reason you couldn't call whatever family members you need right away?
Well, I will say, we have no intention of calling all the family members. We have the intention of calling a few of the family members who serve certain purposes. I can't think of a reason that we couldn't. Obviously, it's not ideal. It's completely out of context. It's out of order.
This is like a gumbo. You are going to put all the pieces that go into that into the pot. And at the end of the day, the jury's going to decide whether it's a good soup or not from the state's perspective. And so I think we get too obsessively stuck on the idea of exactly the order these things need to come in, right? And so I'm not sure why you couldn't call the family members you need up front, and then we take away this concern. I can certainly understand from the defense perspective the need and desire to have the defendants support family here in the courtroom.
I do too. And I guess my preference would be for that, even though it would be out of context and interfere with the state's preference of how to present its case. And I think I do take issue with the defendant being able to direct how the state presents its case to a jury. However, if our options are the immediate family members staying in the courtroom and hearing all the testimony of other witnesses versus calling them out of order, it would be our preference to call them out of order. Thank you.
Judge, I knew that the state's position was that there's no case law to support our position, which is why I just went through several cases where it is his constitutional right, one, for it to be public, and there are cases, as I referenced.
Constitutional right is not absolute, and it bends to, for example, rules of evidence and other rules. And I'm not aware of anything that says that court can't use the exclusionary rule where in good faith a person who was otherwise entitled to be there, including family members, have to be excluded for some period of time.
And that is why I specifically talked about the point that it is discretionary for you. And there's also, Judge, a level of humanity that I hope that you take to serious heart for his family, who is absolutely devastated and dealing with things like headlines that they're going to be called to testify against their son with these types of communications that are happening. And so we're asking that you use that discretion and that you find that humanity. Thank you.
Thank you. I'm going to take this matter under advisement. The defense raised some cases. I want to read those. Though I don't think they were precedent on this court setting. I have reviewed the U.S. Supreme Court opinions cited, but in terms of other states, I'll look at those. I do think, and I'm asking the state to think about to use counsel's word, the humanity. I think that, I can only imagine the family of Mr. Kohberger is devastated by these things. That's nothing that they did. And I think their ability to be here to see the trial is important. And to the extent possible, while also preserving the state's right to a fair trial, should be something that we seek to do. And I think calling them out of order is one way. Now, I know that there is, I don't know why the state would want to call them. I haven't, reviewed their interviews. I don't know anything. I do know there's been an issue raised by the defense relative to purchases on a alleged family account that could be an issue. And so I do see some issues where family members may be important. And so I think there may be some need for exclusion, but I think the best way to handle that is to get them on and off as quickly as possible at the beginning to deal with that. I'm reserving ruling on that. I want to look at it, and I will issue a written order on that in due course. All right, let's talk about the defendant's motion regarding conditions as an aggravator. And this is the concern about using the defendant's alleged autism disorder diagnosis as a aggravator during the penalty phase of the trial, if there is one.
Thank you, Judge. You summarized exactly where I was going to start. This motion is brought in case there is a penalty phase. If there is a penalty phase, Mr. Kohberger has a right to present mitigation evidence. That is State versus Payne, and Roper versus Simmons tells us that mitigation evidence cannot be used as aggravating evidence. This is something that we talked about several months ago when we had our motion to strike the death penalty and ask for trifurcation with the death penalty, and that was denied. But we're bringing it back up because it's really important to make a distinction between things that exist in this case, Mr. Kohberger's autism, something that he didn't ask for. It's a condition that he has, and it'll need to be addressed, but also to prevent the state from using his characteristics of autism as aggravating evidence against him. The state has, and the court has, our expert analysis from Dr. Orr that talks about how autism manifests in Bryan, the things that people might see. And these are things that we've read a little bit about in the media over the course of the case. Bryan's physical body is more stoic, how he sits in one place. And he will look at for a long time. Sometimes he'll hold his hands in a rigid position. And that means nothing. That's just how Bryan is. We seek to prevent the state from using those kind of characteristics against Bryan. We seek that in the way of testimony they might bring. Sometimes Bryan will talk longer than maybe other people want to listen, and that doesn't mean anything.
Well, I assume he's not going to be talking in court unless he's testifying. So
That's exactly right, Your Honor, but that doesn't stop the state from bringing a witness and using that as aggravating evidence against Mr. Kohberger, and that's what we don't want. We want to be able to present, if we get to a mitigation phase, his autism and how that works and how he's learned to live with the conditions that he has, and to prevent the state.
reading the defense's, pardon me, the state's response, it doesn't sound like they disagree with you that it shouldn't be used as an aggravator. And so I think that in terms of what counsel's arguments are, we can control that. I think apart from a jury instruction, I'm not sure what we do, how we deal with that with the jury in terms of the penalty phase, right? If you present evidence of the disorder.
Your Honor, the court can do what we've requested and prevent the state from using Mr. Kohberger's conditions of his autism as aggravating evidence. I think a jury instruction helps the jury to understand how to use mitigating evidence. Our purpose here is to ask the court to take the step of an order. I don't think the state opposes it.
What would that order say?
That order would say that the state would be prohibited from using as aggravating evidence Mr. Kohberger's autism characteristics.
How would they use it as aggravating apart from arguing to the jury that, well, you know, because he has this condition, it means that he is, I'm just making this up, obviously, is inclined to not follow the norms of society and presents a greater danger or something like that.
Your Honor, the order would prevent the state from, on the front end, in presenting their aggravation case, from using the conditions, the way autism works for Bryan, against him, to say that he does things that are consistent with autism and that that's an aggravating circumstance. That's,
I'm just having a hard time envisioning what that would be, how it would be presented in a way that is making it an aggravator.
well, I would hope that it wouldn't be presented that way. But Your Honor, when I look through the mounds of discovery, there are probably 100 hours of interviews of people that Mr. Kohberger went to school with at WSU. And of course, those interviews come just hours and days after the headlines hit that Mr. Kohberger's been arrested in this case. And people that he went to school with, that he interacted with, had unkind things to say about him. And a lot of their unkind things, when you understand them in the context of autism, the way he may stand in a room near a doorway, the way he may look too long at a person, their interviews are different when you know he has autism and you know the characteristics he displays. But those awful comments, those mean comments about him, if the state uses those as aggravators, that's using his autism characteristics.
How do I though, and I don't know that this is a real thing, right, in terms of actual evidence. Let's say there's evidence that he harassed other young females. Okay, and I'm aware of no evidence in that regard. I just want to make that clear. I'm just using this as an example. And let's further assume that that in and of itself is somehow relevant to in a mitigation aggravation penalty phase. Your position is that's due to his his spectrum disorder, whereas the state's view may, no, that's not. That's his view of women, and goes to motive, etc., and goes to his aggravation of the crime in some way, not because of Asperger's, but because of his views, his dislike, and how he responds.
That's exactly the problem, Your Honor. If the state, and
Do you want
I
me to,
wanna
you want
be
me to weigh in and
clear.
say what the factual findings are, that it's this and not that? And I'm not sure I can do that short from a jury instruction that, you know, you cannot use mental health conditions as an aggravating factor.
that's an appropriate jury instruction. And if we get to that phase, my guess is that we'll have one of those jury instructions. But if it's an appropriate jury instruction, how is the jury to understand and properly respond to that instruction if the state has been allowed to run over the top of that during the presentation of their aggravation case? It's that I want to limit. Once we present
There
mitigation,
may be a dispute about the reasons for his conduct, a factual dispute. And that then ultimately is for a jury to determine, not for me.
Your Honor, I believe the court is envisioning a problem that does not
I
exist.
hope so.
I think that the court will not find that that comes up. I think the court can issue an order to the state that would be not to use his conditions of his autism as an aggravator, his diagnosis of autism as an aggravator. That's going to be very similar to the court's jury instruction, and that keeps the trial process clean, and it allows the jury to draw the distinctions and properly use mitigation as it's supposed to do. This is a protective measure to be sure that case law is complied with, and that Mr. Kohberger's constitutional rights are protected.
Thank you.
Morning, Your Honor. So the court is correct that I don't think there's a whole lot of room between the state and the defense in terms of what the law says here. But there are maybe some practical problems in what the defense is asking for from this order. And the court has already nailed this, if the court is to issue an order that says the state can't rely on his autism as an aggravating factor, then anything we try and present, they're going to argue, well, that's a symptom of his autism, and therefore the court's order says you can't use that. I don't think that's an appropriate approach. What I can tell the court is the state has no plans whatsoever to use the autism during the penalty phase as any kind of aggravation whatsoever. There is no plan to put on students from the university to talk about their personal views of this individual. To be quite frank, if we get to a penalty phase, we have a lot better aggravating evidence than the fact that he has level 1 autism. And frankly, it's just not a persuasive argument to ask a jury to impose the penalty of death because someone has autism. So from the state's perspective, this falls largely into one of the categories the court mentioned earlier in a different motion, that it's just really not necessary here. We understand the law. We understand that we're not to use his mental condition as an aggravator. We do, however, reserve the right to present argument as to, if the defense chooses to present it as a mitigating factor, how much weight should the jury give it? And I think we have quite a bit of flexibility there to put on our own evidence as to what exactly this autism means. And so that if the defense tries to say this is the reason that you should not sentence him to death, then we should be able to argue this does not make up for the proper aggravation evidence that we've put forward. I think not only is that the state's right, it's what the statute requires. It's what the Idaho Supreme Court has been very clear that a juror in this situation has to be able to do. It's their duty. That was the Dunlap case. It's their duty to weigh the evidence, including any mental health or mental illness evidence, and make that ultimate determination. And so the state does not believe that this order is necessary or appropriate, but also has no plans of using this as aggravation. Thank you, Your Honor.
Response?
We understand that the state can argue the weight of the mitigation evidence. That's not why we brought this motion. As far as what the conditions of autism are and the way it works in Bryan, the state has received through our expert disclosures reports that describe that. So there's some guidelines for the state there to understand what we are talking about with Bryan's autism. The state will present its aggravation evidence first. The protective order that we're seeking from the court, the order to say you can't use his autism and the conditions thereof in your aggravation case, is easy, it's protective, and if we get to a penalty phase, it is imperative that we protect the rest of the trial. Certainly, if the state thinks it needs to present something in aggravation and there's a question, they could ask the court to revisit the order. This is just a very good, clean way to protect Mr. Kohberger's constitutional rights, and we ask that you enter an order.
Thank you. Right. I don't, again, from a legal perspective, I don't think there's a disagreement about the use of the autism spectrum disorder as an aggravating factor in the penalty phase. You know, the state certainly shouldn't make those arguments and are instructed not to do so. But how that comes up factually, the fact that your expert says that this is one of the symptoms of this, that the state can't put on some evidence that they may disagree about, I'm not in a position to make that sort of blind statement or blind ruling. I think we need to get closer to trial and see specifically what we're dealing with. And so I'm not inclined to issue such a broad order in terms of the actual evidence, the presentation of evidence. I think I can certainly say, don't make that argument that the fact of the diagnosis is somehow an aggravating factor. If and we can deal with the symptomology that the defense contends is part of the diagnosis that the state may take issue with or believe that there's some other relevance of in the penalty phase. And so we'll deal with that on a case-by-case basis as we get there. So the extent of my ruling is simply that the state should not make the general argument that somehow the diagnosis is an aggravating factor. All right. Why don't we take the morning break? We'll take 10 minutes and be back at about 20 till.